Good morning. The level of stupid in my comments has been pretty interesting. Let's start off with whether or not the government is doing a hit piece, or they were trying to do a hit on Weinhaus. If they were trying to do a hit on Weinhaus, they did the world's worst job ever. They shot the guy twice in the chest and twice in the head, and then they called an ambulance and saved his fucking life. That is job poorly done. They could have sat there while he bled to death and waited to call the ambulance, but they didn't do that. So that's it. They're the world's worst hitmen. Well, obviously the trial must have been rigged, right? Well, fun fact is he went in there on 8 charges, I think, 7 charges. There were 2 charges related to the threats that were dismissed by the judge on a motion to dismiss. The judge agreed that 2 of the charges couldn't stick. If the judge was out to get him, why would the judge have done that? There's a goddamn skunk. Nope, let the skunk cross the street. So that doesn't make a whole lot of sense. Well, obviously the prosecutor was trying to get him. That's the prosecutor's job. Why would the defense counsel be trying to get him, not going after the skunk? All right, are you done? You done with the skunk? All right. Obviously the defense counsel was on his side. Whether or not you think the defense counsel was effective, it's up to you. I mean, people are pretty strongly opinionated on this based on no real evidence. But for whatever reason they're buying into the bullshit that Lysander Spooner and that cadre of sovereign citizens are putting out, because, well, why wouldn't you? These guys are all reputable fellas. Anyway, so maybe it's the jury that's out to get him. The jury of his peers. The jury of people who went through voir dire to get on that jury panel. And the defense attorney had his opportunities to challenge with peremptory challenges and to challenge for cause. And yet they survived that process to make it onto his jury. But maybe they were all biased against him, because obviously in your minds the facts mean that Weinhaus was innocent. And yet they had 5 charges go in front of him. One of the charges was an assault on the corporal, and they didn't find him guilty of that. So, I mean, if they wanted to, they could have. Well, maybe, let's go back to the judge. Maybe the judge, the judge gave him 30 years for this. Maybe it was the judge. Maybe the judge is out to get him again. Maybe the judge changed his mind after dismissing 2 of the charges. Well, the judge gave him his sentences and had him run concurrently. That means that it didn't matter. The marijuana possession didn't matter, because it was less than the 30 years that he would get from one of the other two charges he was convicted of. The possession of opiates didn't matter, because he got sentenced to less than 30 years for the possession of opiates. And the other 2 charges he got sentenced to 30 years for. Only one of he's running them all concurrently, so only one number matters. The judge could have done them worse, theoretically. The judge is probably just following sentencing guidelines. I mean, honestly, the judge is probably following sentencing guidelines. I think most states use sentencing guidelines at this point. So I'd be surprised if the judge did anything different than what he was supposed to do. If he had, I'm sure it would have been appealed on that issue. So then he appealed it to a circuit court. Now, if the county was out to get him, the circuit court covers a lot of counties. And the circuit court affirmed the trial court's decision. He then petitioned for a writ to the Missouri Supreme Court. They denied his writ. They obviously have never heard of this dude. They don't care about this dude. And they said, you don't have a real issue. Sorry. So then he motioned for ineffective assistance of counsel. It was heard by a petition court, whatever that is. It's probably a court in jail, or a court in prison where prisoners can go to have their petitions heard. And it was denied. So he appealed that. It went up to the Circuit Court of Appeals again. The Circuit Court of Appeals addressed every alleged fact that these people are now proposing in my comment sections as somehow vindicating Weinhaus. The court addressed them. And he lost. So then he filed a writ, something or the other, that the federal district court gave him the opportunity to amend. So he amended it to a writ of habeas corpus, and the federal district court reviewed all of the evidence because they could. They looked at everything, and guess what they found? He's got nothing. He's got nothing. So the questions become, why do people think that these arguments that they're making matter? Why would it matter if the holster was on his left hip or his right hip? Explain that to me. Now, as an attorney, the only way it would matter to me would be as impeachment evidence, would be to suggest to the jury that if Officer Folsom is saying that the holster was on the right hip and no one else saw it on the right hip, they all saw it on the left hip, then perhaps Officer Folsom is lying. That's what I would use it, how I would use it to suggest to the jury that they can't trust the testimony of Officer Folsom. Guess what? His attorney did just that. Now, we don't know conclusively what hip his holster was on. All we have is habit evidence by people who may or may not know his habit. That it was said, it suggested that he habitually wore his holster on his left hip, facing backwards, so that he could wear his seatbelt, because that's the only way he could fasten his seatbelt. Well, number one, did he do it this time? Number two, did he wear his seatbelt this time? And number three, did he adjust it upon getting out of the car? Number four, why the fuck would we care which hip it was on? We don't. I'm going to tell you why. Let's say, and I don't know the elements to the particular offense of, armed assault against a law enforcement officer, but let's just pretend that the elements are pretty simple. Let's just pretend that you have to draw a firearm, and a cop, which is an element, has to be a cop, would have to be placed in reasonable apprehension of imminent bodily harm by you drawing that firearm. So it's three elements. Did you draw a firearm? And did a cop, which is the second element, become reasonably apprehensive of imminent bodily harm as a result? Which hip he wore the holster on doesn't affect any of those elements. It does suggest, however, that he did in fact have a firearm, which is one of those elements, because he has to draw a firearm. You could split drawing a firearm into two elements. You could say it has to be a firearm and he has to draw it. Those are more law school questions that, various professors will disagree with. But at the end of the day, all of these suggestions of error in the testimony of Folsom don't directly address whether or not Weinhaus pulled his gun. The question is whether Weinhaus said, "Don't shoot me," or "You have to shoot me." There's a question on that. The jury heard it. The jury listened to it. They still found Weinhaus guilty. But it wouldn't affect any of the elements of the crime. Saying you're going to have to shoot me doesn't make him guilty of assault on a police officer. Saying don't shoot me doesn't make him not guilty of assault on a police officer. It's not a part of the crime. And I don't know the elements of the crime. I do know it's not part of the crime because 2 courts reviewed it and said it's not part of the crime. It's immaterial. And none of these knuckleheads have read those decisions, which I posted. None of them have. Now, is there a possibility that Weinhaus is innocent? Yes, absolutely. There is a possibility. Is it a good possibility? No. It is a very poor possibility. It is a remote possibility. It is improbable. I had one knucklehead try to bet me a steak dinner, like I'm going to trust one of these chowderheads. He wanted to bet me a steak dinner that I couldn't prove to him that Weinhaus did it. Well, that sounds great and everything. Boy, love the cocksure bravado. But how about you prove that Weinhaus didn't do it? Because the state has already proven beyond a reasonable doubt to a jury of Weinhaus's peers that Weinhaus did it. There is beyond a reasonable doubt evidence that Weinhaus did it. Why you think you're special and I have to prove to you that he didn't do it is beyond me, or that he did it is beyond me. The case has been reviewed multiple times. There are no errors in it, or at least no errors that are worthy of a new trial. So, sorry guys, you're barking up the wrong tree. When I said that your only real recourse is the governor for a pardon, that's it. And he wasn't popular. Go dig on it. He never won any of his elections. He never won. The people of his communities hated him for the most part. Hashtag not all. He had a small group of people who liked him. People who went to raves liked him. Everybody else, the actual citizens of the community who stayed in the community and didn't just travel there for raves, didn't like him. That's why you've never heard of him. He's not effective. He's not important. He's some schlub who tried to rock the boat in Missouri, got caught with drugs, was going to get arrested for drugs, and decided he wanted to resist arrest. Because in his mind, he had a right to resist unlawful arrest. I'll bet you, because that's what all these knuckleheads think. I have a right to resist unlawful arrest. I'm going to draw my gun. Oh, wait, why did I get shot 4 times? Cops are mean. They just want to kill me. Obviously, that's speculation on my part, but the evidence does strongly suggest that he drew a firearm beyond a reasonable doubt. He drew a firearm at the cop beyond a reasonable doubt. So you get to tell me why he drew a firearm. I'm going to say because he thought he could resist arrest. Maybe it was suicide by cop. I don't know. Anyway, I'm rambling now. Thanks for watching. Have a great day.